Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve that time, if you let me know when you get started, I'm keeping the clock. I can let you know about the passage of time. We have read the briefs and we're ready to proceed when you are.
Thank you, Your Honor. May it please the court, counsel, I would like to reserve 5 minutes for my rebuttal, Your Honor. Your Honor, this is a case that involves a tenant in a residence in Richfield, Ohio. And the house was infested with toxic mold. My client, Sharron Coeurvie, was exposed to that mold and suffered permanent and extreme damage throughout her body. The case was tried to a jury, and the jury ultimately found that there was no negligence on behalf of the landlord. We believe that the trial court erred in 3 different respects, and these are the issues that we believe this court must decide. The first issue is whether the jury disregarded the manifest weight of the evidence in finding no negligence on behalf of the appellee landlords. The second issue is whether the trial court erred when denied the appellant's motions for J&OV and/or a motion for a new trial. The third issue that we have presented is whether the trial court erred when it added the word significant to the jury instruction in front of the word risk, amplifying the standard that the plaintiff had to prove. The facts of this case are rather lengthy and rather complicated. My client rented the appellant's house in Richfield, Ohio in approximately April of 2010. She did not permanently reside there initially, although she resided there every couple of weeks. She was moving from Chicago to the Akron area. She had a 1-year lease. She began permanently residing in the house in September of 2010. Prior to renting the premises, she did a walkthrough with the landlord's agent, who happened to be one of the landlord's father, a Chuck McGonical. During that walkthrough, my client specifically inquired about a few issues regarding what she believed were potential mold in the house. She was reassured.
Did you specifically refer to it as mold, point out to him that?
Yes, that was her testimony at trial. She specifically, in the walkthrough, said that these different areas, these appear to be mold. Is this an issue I should be concerned about? My client didn't know anything about mold. She was assured that no, that wasn't mold. There was no mold in the house, and that the house was safe and habitable.
Was this the mold in the basement, or was this mold elsewhere?
This was not the mold, Your Honor. This was not the mold in the basement. This was mold throughout some of the hallways.
Or what she thought was mold.
What she thought was mold, specifically around a lot of the windows as well, and the fact that the entire outside of the house appeared to have a blackness to it, and she wasn't sure what that was. But she observed mold on the outside of the house, some on the inside of the house, but she was assured by the landlord's agent that that was not any issue. Now, she did not reside in the house on a permanent basis until approximately September. So the first 4 or 5 months of her lease, she was just there from time to time. She moves in permanently in September 2010. She began to not feel right, but wasn't sure what the issue was. However, in February of 2011, the issue really came to a head. She had been told by some people who had visited the house that the house smelled moldy, it smelled musty, and she was also feeling much, much worse. So what she did was she eventually contacted the Summit County Health Group. They came and looked at the house, and what they discovered was that in a room in the basement, a room that didn't have a concrete floor, it just had a dirt floor. This is a very, very old house, Your Honors. In that floor, she discovered that there was between 1 and 4 inches of standing water throughout the entire Kellys were notified of that issue. She remained concerned. She had a mold person come out. The first one was hired by the landlord. She wasn't satisfied with what this gentleman did because he barely did any inspection whatsoever. So she called a private mold remediation company, experts in the field, to come out and look at it. That was AirGuard. They inspected the property. They found that there were visible signs of mold on the main floor, serious issues with the roof and infestation of water coming in, mold in the upstairs hallway, in the chimneys, mold on materials in the basement, confirmed that there was 1 to 4 inches of water, that the basement ceiling was covered with mold, and that the heating system, which was in the basement, was also sucking all of this mold air up and pumping it through the house whenever it was heating the house. This mold expert did air testing, which he sent out to an EPA lab, and it found Stachybotrys, which is a dangerous black mold, and Aspergillus, both very dangerous and harmful. And although these exist in nature, in this house, the EPA lab found that these levels were approximately 90 times what a normal house would have. As a result, she again notified the landlord of some of these issues. She was advised not to live there anymore. So she didn't stay in the house anymore. She had to throw all of her materials away because they were all infested with mold. Anything that's porous or has cracks, the mold will get into. She continued to have very, very serious health problems. So
At what point in time was she advised not to live any longer at the rental premises?
almost immediately after the gentleman from AirGuard was there.
And when was that?
That was the end of February of 2011, Your Honor.
Was the, I'm sorry,
Yeah.
was the landowner or the landlord also present during the inspections, or were they made aware of the results of the inspections?
They were not present for the inspections, Your Honor. They were, however, made aware of these different inspections and what had been found. So at trial, we also hired an environmental expert, Connie Morlock. This woman has been accepted by courts throughout the United States, has been cited by the Michigan Supreme Court, has testified in numerous jurisdictions. She also did two different things. She authored two different reports, and the first report was based upon the information that she received from the initial evaluation by AirGuard. The second thing that she wanted to do, and we had to argue and fight to do this, but she then conducted an examination and a complete inspection of the premises in which she lived. She was there for a full day. She, and this was her testimony, she found that there was historical issues with mold. She found that, and this is from her testimony, that there was historical evidence of mold presence because of the substandard maintenance of the house, which caused excess moisture. And moisture is what causes mold. She observed current and past water damage and mold growth in the windows in the living room, the dining room, the basement ceiling, the master bedroom, the bathroom, the kitchen, the roof, and the attic. She also found that there were unused building materials in the basement which contained penicillium, another very dangerous mold. She indicated that industry standards required the removal of the actual mold growth, which had never been done. She found that the preventative maintenance in and around the house appeared to be non-existent for over 20 years, and that the lack of such maintenance was the cause of the Stachybotrys, the dangerous mold. She confirmed what had been done by the other labs. She found that the house was infested with both penicillium and aspergillus. She also found that because Ms. Coeurvie resided in the premises, she had been exposed to 3 different bad molds: penicillium, Stachybotrys, and also to Pseudomonas while she resided in the house. She testified that the mold had never been properly remediated and it still existed. Now, at trial, the landlords, through their counsel, conceded that there was mold throughout the house, conceded that, in fact, it was dangerous. What they argued is that there hadn't been any notice. Now, in these cases, we have to have either actual knowledge, which I believe we proved when Mr. McGonical testified to the fact that he knew that what was on the house was, he called it mildew. Everyone knows mildew and mold are the same things.
And Council, you're just now reaching that 5 minutes. You can keep going or reserve as you wish.
Okay, I will take one more minute and just have 4 minutes in the call. So in terms of asking for a manifest weight of the evidence, in State ex rel Rogers v. Elbert, courts have said the trier of fact isn't free to reject all of the evidence if the evidence isn't contradicted. Here, there was no contradictory evidence on two important parts. One, that she was exposed to mold and that she had medically related mold illnesses. And two, the evidence of the expert was that that mold had been present. Their expert, however, never visited the house, wasn't an expert in molds, and was merely there to say, well, she shouldn't examine these things. I will follow up further in my remaining time, unless you have a question, Your Honor.
I do have a question, Counsel, regarding, I guess I'll put your second piece of evidence first. If I'm right, wasn't there discussion about the time frame? It was like a 28-month time frame passed?
That is correct. There was 28 months that had lapsed between when she lived there, but what our expert stated is that,
Let me get to
I'm sorry, I
my point.
apologize.
Doesn't that take it out of the category of uncontradicted or challenging the credibility of a report or testing that happens 28 months later?
No, Your Honor, and for two reasons. Number one, they fought us getting in there, and number two, the expert said that without a doubt, this existed years ago. It's nothing that we have just found. That was the uncontradicted evidence. Their expert never even did any testing, never even went to the house.
Did the expert say without a doubt?
She said to a reasonable
Wasn't
degree.
that, did the expert say without a doubt the owners knew about it?
She did not say without a doubt the owners knew about it, but this is about constructive knowledge, whether or not you should know. There's no way anyone could say without a doubt you knew about it unless they testify to that. However, the law allows constructive knowledge.
I'm only getting to the contradicted part. I understand
Fair
your
enough, Your Honor.
constructive knowledge, but I'm just getting to the point about you saying it's uncontradicted. Okay, thank you.
Thank you, Your Honor.
May it please the court, Mr. Burke. My name is Jim Gutbrod. I represent Richard and Wendy McGonical, who are the landlords in this matter. The first and main assignment of error here is that the verdict was against the manifest weight of the evidence. This court and many other courts have said that judgments supported by some competent, credible evidence going to all the essential elements of the case will not be reversed by a reviewing court as being against the manifest weight of the evidence. The weight to be given to the evidence and the credibility of the witnesses is primarily for the finder of fact, and those determinations by the trier of fact are given great deference. The evidence, if the evidence is susceptible of more than one construction, we must give it that interpretation which is consistent with the verdict and judgment. Counsel, this matter started 7 years ago, and this case has already been to the Court of Appeals once. We were granted summary judgment by the trial court initially. We came back up here, the court sent it back down, and we tried the case. We tried the case for 8 days, a full jury trial with many witnesses and much evidence. And the jury came back in several hours with a unanimous verdict that my clients were not negligent. That should have been the end of this. But here we are back here again, now 7 years later, and still litigating this case. The evidence in this case was not just that there was competent and credible evidence, but the evidence was overwhelmingly in favor of the McGonicals. As we've already talked about, there's two main issues. Number one, was Sharron Coeurvie exposed to and injured by mold while lived in the house? And I think the evidence was very strong that she was not. And second of all, were the landlords, the McGonicals, who lived in Florida, did they have actual or constructive knowledge of the hazardous condition, that is, injury-causing mold. The lease was from April of 2010 to March of 2011. The appellant lived there part-time till September of 2010, and then full-time from September until February. There is no doubt, no contradiction, she moved out on February 24th, 2011. She never mentions the presence of mold until February 23rd, 2011. One day before she moved out. Even in her complaint, she acknowledges that she did not notify, paragraph 21 of her complaint, that she did not notify the McGonicals of the existence of mold until February of 2011. Now at trial, she claimed that she pointed out this mold, as counsel has referenced, during a tour of the house back in February of 2010. She said that there was mold in the cupboard in the master bathroom, and she saw a couple dots of something in the master bedroom window. She said she told Chuck McGonical, Rick's father, on that day, who was helping her with the tour. But counsel, or your honors, there's strong evidence contradicting her testimony. She, first of all, the father, Chuck McGonical, who testified at trial, said that there was never a discussion with Ms. Coeurvie about mold on that date of the tour, February 2010. There was also the testimony of a lady by the name of April McCarty, who, for no benefit of herself, came up from North Carolina to testify at trial of the case. She was living there with her family at the time of this tour. And she testified that at no time when she lived in the house did she notice any mold, and in particular, she never noticed any mold in the master bathroom cupboard, which she used daily. Ms. Coeurvie, number 3, Ms. Coeurvie had no witnesses to corroborate this statement that she supposedly made. Number 4, she never insisted that these 2 spots of mold that she allegedly observed be cleaned up. This was despite the fact that she made numerous requests for things to be done in the house before she moved in, and in particular on the day that she moved in, she insisted that the house be cleaned thoroughly while she was there. But there was never any mention of mold.
Was there a pre-existing condition history here where she might have, was there any evidence that she had these symptoms or these diagnoses before she moved into the house?
There was some evidence of that. There was just tremendous amount of testimony and evidence about her condition, and Ms. Coeurvie, to hear her testimony, has every problem known to man, and much of that was there before.
So there was somebody testifying as to pre-existing
Well, there was a whole
illnesses related to mold or not?
Well, there was a whole issue on the testimony of one of the pathologists, who, if you'll remember, was a crazy man who thought that this was all part of a government scheme to overtake the world or something.
And he testified that she did not have these conditions prior to moving into the house?
That's what he said.
What did you offer? Anything? Any testimony to
I think there was quite a bit of cross-examination of their expert doctor, and that's what we had.
Okay, thank you.
Going back to the point about this so-called mold that she saw when she did the tour, when she moved in April, and during the time that she lived there, she did not observe any mold. She testified to that at trial. And then Rick McGonical, my client, testified that he had owned the property for 9 years with a variety of tenants, and no one besides Ms. Coeurvie had ever complained to him about the presence of mold. In fact, he testified that Ms. Coeurvie never complained to him about mold until she had actually moved out of the property. All right, so in light of the lack of actual evidence, the appellants then went after the idea that there was historical evidence, that this was not a matter of maybe actual knowledge, but maybe there was constructive knowledge, and they brought in Connie Moorbach to testify. And as Judge Callahan has pointed out, most of her testimony was based upon an inspection she did 28 months after Ms. Coeurvie had moved out. And yes, we did contest that. We did make the point with the court that she shouldn't be allowed to do that, but the court allowed her to do that testimony. She wrote a whole new report, and she testified at trial. The problem is that a significant part of her testimony came from dust samples that she collected in June of 2013, 2 years later, more than 2 years later. However, she was unable to account for how many times the floors from which she took the dust samples had been vacuumed, washed, dusted, waxed, how many times the floor had been walked on by either human beings or dogs, or how often windows were opened and dust in particular came in through the windows. Number one. Number two, appellant was unable to provide any witness, testimony, or other evidence about these occasions where there was flooding or intrusion of water in the past. We did have an expert, Joan Sabler, who did not inspect the house but did evaluate the report of Connie Moorbach. And Joan Sabler testified that a conclusion could be drawn about the state of affairs 28 months before the testing was done was very unlikely. She testified that she herself had never done that she had never heard of it being done, and had never even read of it being done. She called into question, a serious question, the veracity and the accuracy of Moorbach's testimony. But we don't even need to rely on that, because the testimony of the other people who lived there was so overwhelming. The McGonicals themselves testified that they had purchased the house in 2006 and lived there from 2006 to 2009 with 2 very small children. Wendy McGonical, the wife and mother, testified that in that 3-year period, she never observed any mold or moisture, wetness or dampness in any of the rooms of the house. She also testified that she did laundry in the basement, which was the main place where there was any mold ever found in the house, in the basement. She used to do laundry there in the basement and never noticed any mold in the basement. But not only that, Sharron Coeurvie herself testified that she did laundry in the basement on a weekly basis when she lived there, using the washing machine and hanging clothing up on a line in the basement, and that she never observed mold in the basement until 4 days after she had moved out of the house. Sharron Coeurvie herself never observed any mold anywhere in the time that she lived in the house until the day before she moved out. I also have already had to mention to you the testimony of April McCurdy, who came up from North Carolina to testify. Did you ever at any time notice any mold anywhere in the house during the time that you lived there? And she lived there right before Sharron Coeurvie moved in. And she had lived there for almost a year. No, I did not. And you spent most of your time in the house. Yes, I was at home with the kids most of the time. She actually did some she was a realtor, and so she was quite familiar with mold. And she made it very clear that she had never seen any mold there. Chuck McGonical testified he lived in the house for 2 years after Sharron Coeurvie moved out. He said he never saw any mold. But how about Karen and Steve Palmer, the wife and husband, who also testified in trial? They moved into the residence in February of 2013 and had lived there continuously and were living there at the time of trial. They had nothing to gain by their testimony. They came in and testified. And Karen testified first. She was shown pictures from the office, from the dining room, the kitchen, the foyer, the living room, the linen closet, between the living room and master bedroom, the master bedroom, the master bathroom. She testified that each of those she had never, ever seen any mold. Her husband also testified, Steve Palmer, he stated that he had never seen any mold any place in the house in the 2+ years that he had been there. He was shown photos of the basement, which is where the mold was, which at that time included his inflated hot tub. He also testified to having 2 fish aquariums in the house that he needed to replenish the water in the aquariums on a weekly basis due to evaporation. He had never had any mold issue in the house any place, the basement, the cupboard, anywhere in any of the rooms. He then testified to other houses that he had lived in, including his parents' home and others where there were mold problems. Therefore, he was familiar with the presence of mold. And as I've mentioned, Rick McGonical himself testified that in the 6 years since he and his family had moved out of the house and were renting it to others, no one else besides Sharron Coeurvie had ever complained regarding mold in the house. Indeed, even Ms. Coeurvie did not complain until she was already essentially moved out of the house. So as far as this decades of mold and decades of water intrusion and flooding and so on, there was absolutely no testimony. There was no evidence of that except coming from Connie Moorbach.
Mr. Gutbrod, could you address counsel's challenge to the jury instruction and the addition of the word significant?
Sure.
Did that come from Ogier or case law, or do you know where that came from?
I don't remember. I don't remember if that came from Ogier or not, Your Honor. This was the statement. Therefore, if the McGonicals knew or should have known by exercising reasonable care that there was toxic mold on the leased premises, or that there was a significant risk that toxic mold would develop there, their failure to prevent or remedy that condition was negligent. So folks, we're talking about one word, significant. And I submit to you that when you look at the jury instructions, you'll see that if you don't use the word significant, the end result is they would be extending the responsibility of the landlords too far. Because the judge was saying either, number one, if the McGonicals knew that there was toxic mold on the leased premises, number two, should have known by exercising reasonable care that there was toxic mold on the leased premises, or three, that there was a significant risk that toxic mold would develop there. Their failure to prevent or remedy that condition was negligent. In my opinion, the court was going above and beyond on behalf of the plaintiff under those circumstances in giving that jury instruction.
Was that even an issue in the trial? Whether or not there was a significant risk that mold would develop?
Yeah.
The case centered around either there was or there wasn't.
Exactly, Your Honor. There was no testimony at all, no evidence at all on that point. That there was a possibility that somehow there was a significant increased risk that there could be mold in the future. That was never an issue in this case.
And counsel, regretfully, I need to let you know that you've utilized the entire 15 minutes allowed.
Thank you, Your Honors. I think I addressed the main points dealing with the manifest weight of the evidence.
Thank you.
I submit that when the court looks at all the evidence, you'll see that not only was there sufficient, competent, and credible evidence, the evidence was overwhelmingly in favor of the McGonicals.
Thank you. Counsel, you have about 2.5 minutes remaining.
Very good. I'll be quick. Thank you. In terms of where did the word significant came from, it didn't come from Ogier, and it doesn't come from case law. It came from Mr. Gutbrod. That's the jury instruction he asked the judge to present. And he is correct. It does dramatically change the standard. And it wrongfully changes the standard because it's not significant. It's whether or not there is a risk. And Your Honor, to your point, one of the issues in the case was because of all the historical issues, the issues with the roof, the issues with other water, the issues with prior things with mold in the house, that is why it was whether or not they could be constructively put on notice that this problem was going to be created. The second thing is in regard to him saying that there was no evidence of mold. Chuck McGonical did testify that he had observed mold in the basement and painted it over at page 843 of the transcript. He observed mold in hall closets and he cleaned and inspected it. He also subsequently observed mold all over the basement ceiling that he cleaned it up. He also observed that there was water damage and he admitted that the roof had leaks in the house, and the actual landlord admitted that the black mold, and you can see it from the pictures, that covered the whole outside of the house, that he was aware that that was mold. In regard to no evidence that she was exposed to mold, Actually, the contrary is true. There was no evidence that she wasn't exposed to mold. They presented zero medical evidence. The doctor who testified on behalf of the plaintiff is a nationally renowned mold toxicology expert who has spoken and testified throughout the country on the issue. She said, in fact, she was exposed, that's where she's getting these problems. In regard to Connie Moorbach and the problem with 28 months later, Connie Moorbach actually had data from the day of the initial issue from Gil Gottlieb from the testing that was done the very time. The testing that she did 28 months later was just confirming all of those things. She had evidence from the day that it occurred. And in fact, that shouldn't even be an issue because they conceded that. Mr. Gutbrod conceded at trial that the levels of penicillium and aspergillus were dangerously high and shouldn't have been there. I'd ask that you reverse the trial court and either send the case back, find on liability, send the case back for a damage hearing, or send it back for a new trial. Thank you very much, Your Honors.
Thank you both for your presentations today. Court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides, as well as close